What's up? What's good, everybody? It's your boy Tommy Springfield and your favorite host back up in here with another one of these videos. And as you can see by the thumbnail and by the title, we looking at that Young Thug YSL Rico paperwork. That's what we looking at today. And if you're new here, click that like, share, subscribe, hit the bell, click all so you can get notifications every time I do one of these videos. And why not? It only helps a small channel gets bigger, and then that small channel can do bigger things. But as you can see on the screen, we got the paperwork. Unless you've been under a rock, there's been a lot going on. This judge is definitely biased. And what we have here is a motion to get rid of his ass. And it's a good motion because a lot of stuff has been filed by Little Woody's attorney, which she was the one that told on the judge having secret meetings. And we gonna get into reading that paperwork. You know, it's a 420 channel over here. If you don't like weed smokers, this ain't the channel for you. So get your coffee, get your blunts, get your tea with the fruit in it. And, you know, I smoke only the best. If you was here, I'll let you hit it. But you not here. So I would take my toke and get to read it. So this is a motion to disqualify, recuse Judge Glanville from all further dealings in above referenced case and motion for mistrial, which excuse me, goaded by the improper conduct committed in concert by the court and prosecution. So the title alone tells you shit finna pop off because they're accusing the judge of being down with the prosecution. So Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case. Motion for mistrial, which was goaded by the improper conduct commitment in concert by the court and prosecution. In support of this motion, Mr. Williams shows as follows. Undecided counsel represents Mr. Jeffrey Williams in the above referenced case. The jury trial of multiple accused persons commenced January 4, 2023 before Fulton County Superior Court Judge Glanville. The trial is expected to last at least through the end of 2024 calendar year. On Monday, June 10th, 2024, which is a couple days ago, and as you can see, this motion was filed today. So we get paperwork over here. We don't be playing. We get that paperwork. So, on Monday, June 10th, 2024, within 5 days of the filing of this timely motion, this court, along with the prosecutor, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, for whom an order of use immunity had been issued on Friday 7th, 2027. No notice of this ex parte meeting was provided to any attorney for any of the criminal accused in the case. In fact, the accused and their counsel were in the dark that this Star Chamber meeting occurred. So, what I've read so far is that the prosecutor and the judge and Lil Woody, Mr. Copeland, had a secret meeting called ex parte, and they didn't invite the defense, which is illegal, which is wrong, which is one of the many reasons Young Thug will get his case overturned. But if you know anything about doing time, you do a lot of time waiting for your appeal. I got a little brother who had an appeal. He was sentenced to 15 years. He didn't get his appeal for 10. So, and he got out he gave them 5 back, but you did 10 waiting for that appeal. So appeals ain't the greatest thing in the world. So Mr. Copeland had previously been called to testify on Friday, June 7, 2024, asserted the Fifth Amendment privilege in open court in front of the jury and was held in contempt and summarily incarcerated until such time as he agreed to testify pursuant to the grant of use of immunity. Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that an ex parte meeting occurred on the morning of June 10, 2024, only after undersigned counsel revealed, based upon information and belief, that this is an impermissible meeting occurred. At the earliest opportunity on the afternoon of June 10, 2024, the court was informed, based upon information and belief, that the ex parte meeting with the sworn witness Kenneth Copeland and the prosecution occurred earlier that day. That witness had made factual omissions and that statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Mr. Copeland could be held in custody on the contempt. The court denied undersigned counsel's request for the transcript of the ex parte meeting and denied the timely motion for mistrial based upon this improper and illegal ex parte meeting, which violated Mr. Williams' constitution and statutory rights, including the right to due process, a fair trial, a fair tribunal, ethical prosecution, and right to be present at every critical stage of the proceedings under the Georgia Constitution. So what that just said is Young Thug had a right to be represented in those illegal meetings that they had. And the judge has denied all their motions to get what was said in those meetings and, what was talked about. Now, if you're denying that, we know something was talked about that shouldn't have been talked about. And it says a transcript of the relevant proceedings on June 10, 2024 has been ordered from the court reporter. A video recording of the entire June 10, 2024 trial proceeds can be accessed online. So you can go watch the trial, but we ain't finna do that right now because it's my time and it's my show. But Uniform Superior Court rule in Georgia Code of Judicial Conduct, delayment rules governing ex parte communication. Uniform Superior Court rule generally prohibits ex parte communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties of their attorneys concerning a pending or impeding proceeding. Ex parte hearings are only authorized in the case of the extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with the opportunity of attending and voicing any objection that may be properly registered. Judges shall accord to every person who has a legal interest in the proceeding or that person's lead lawyer the right to be heard according to the law. Judges should not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matters, subject to the following exceptions. So they're about to give us the rules of the only time a judge should have a secret meeting, which we know this judge had secret meetings and he basically admitted it and he's out of line. So, where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that did not deal with substantive matters or issues on the merits, provided that A. The judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all other parties of the substance of the ex parte communications and give the parties an opportunity to respond. The judge may obtain the advice of a disinterested expert on the law applicable to proceeding before the court. If they give notice to the parties of the person consulted and the substance of the advice and afford the parties reasonable opportunity to respond. The judge may consult with court staff and court officials whose functions are to aid in carrying out adjudicators' responsibilities or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. Judges may, with the consent of the parties, confer separately with the parties or their lawyers in effort to mediate or settle pending proceedings. Judge may initiate, permit, or consider ex parte communications when authorized by the law to do so, such as when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on therapeutic problem solving or accountability courts, including drug courts, mental health courts, and veteran courts. This court violated, I ain't gonna say the numbers, in Georgia Code of Judicial Conduct. The court has joined the prosecution team and is a bias against Mr. Williams and favorable to the prosecution as objectively demonstrated on June 10th, 2024, as well as throughout the pendency of this case. So, with that line right there is a dangerous line. That line, this court violated. The court has joined the prosecution team and is a bias against Mr. Williams and favorable to the prosecution as objectively demonstrated on June 10th. You don't say that to a judge. That's like the worst thing you can say to a judge. You are on the prosecution team. You are with the prosecution. That's one of the worst things you can say. But we gonna go on. The trial court rejected undersigned counsel substantive requests for information about the unlawful ex parte meeting, and the court denied undersigned counsel motion for mistrial. Instead, the court sternly demanded to know how undersigned counsel came into possession of the information about the ex parte meeting. The prosecutor sternly sat muted and permitted this injustice to occur and for the court to attempt to intimidate undersigned counsel later. Love, a lawyer currently employed with the Fulton County District Attorney's Office, argued that the ex parte hearing with the witness Copeland was ethical, just, and proper. The other prosecution still remained mute. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on the state bar rule of professional conduct, which states in part that a lawyer shall maintain in confidence all information gained in a professional relationship with the client, including information which the client has requested to be held inviolate or to disclose of, which would be embarrassing or likely be detrimental to the client, unless the client gives informed consent, except for disclosures that are implicitly authorized in order to carry out the representation or are required by those rules or other law or by order of the court. Comment 5, the rule whatever specifies states the principle of confidentiality is given effort in two related bodies of the law: the attorney-client privilege, which includes the work product doctrine, in the law of evidence, in the rule of confidentiality established in professional ethics. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in a professional relationship. Whatever its source, a lawyer may not disclose such information except as authorized or required by the Georgia rules of professional conduct of other law. The court ignored the ethical rules and relied upon and continued to demand undersigned counsel to reveal the source of the information, claiming that the way that the undersigned counsel obtained that information was somehow unlawful and baselessly accused the undersigned counsel on the record of potentially acquiring the information through eavesdropping. In response to the suspicious activities in the permissible demands of the court, undersigned counsel relied on the ethical mandates of Rule 1.6 and the Fifth Amendment right to remain silent and declined to provide the source of information which had been proper. The court is also so biased against undersigned counsel and or Mr. Williams, the court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and all others. So, what we got going on here so far is that on June 10th, when Brian Steele, Young Thug's lawyer, called these people out, he was threatened, he was intimidated. Instead of the judge following the law, he wanted to know who told, and that wasn't right. The court issued a written order of contempt and incarceration for Brian Steele, imposing a maximum sentence of incarceration for 20 days. The Supreme Court of Georgia has granted a writ of to address the appeal of the contempt order and has granted undersigned counsel a supersedious bond. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceedings where the announcement of punishment is delayed and where the continuous conduct was directed toward the judge, or where the judge reacted to the contumacious conduct in such manner as to become involved in the controversy. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Here, the court involved itself in these proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' right. This created a conflict of interest for the court because its own unethical conduct is questioning at the heart of this issue. The court then compounded its abuse of power by proceeding over the very contempt hearing where its own rules violated prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. Further, the prosecution sat muted and permitted the court to attempt to interrogate and intimidate another member of the bar, which the bar who reported a violation of the law, and also promoted the court's wrongful conduct by asserting that the ex parte meeting was improper. The court denied Mr. Williams and undersigned counsel their due process rights, as undersigned counsel has rights to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceeding. And Mr. Williams had the right to learn all the facts and circumstances of this critical stage of the proceeding that occurred in his absence ex parte. The court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights due to process. Hey man, if you in here, click that like, share, subscribe, hit the bell, click all so you can get notifications. Why not? It only helps the channel grow. It's not gonna hurt you. It's free. And one day I'll be a big channel if we all just like and share. Who cares if you like me or the channel? Why not let someone grow? But anyways, because I'll recuse all of y'all. I'll file a motion. But, so, the court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights to due process, right to fair tribunal, right to fair trial, and right to be represented in presented in effective assistance of counsel. This court's refusal to acknowledge those rights and protections has created an unfair tribunal based upon bias against Mr. Williams and or his counsel and favoritism toward the prosecution. Motion to disqualify recused Judge Glanville is timely filed as Uniform Superior Court rule mandates that time for filing a motion to recuse shall be not later than 5 days after the afferent first learned of the grounds for disqualification. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under USCR 25.1. It is filed within 5 days after the afferent first learned of the alleged grounds for disqualification, excluding Saturdays and Sundays. Thus, this motion to disqualify recuse is timely filed as the reason for this disqualification recusal was first learned on Monday, June 10th. The record also reveals numerous instances during trial when judges' behavior appears to have been biased against Mr. Williams, counsel, and partial in favor of the state. See Millhouse versus State. Contains that a trial judge's derogatory or prejudicial statements and demeanor will be considered so long as a reviewable record has been complete. One method of creating such record is to obtain testimony from witnesses who were in the courtroom at the time of the incident in question. The record reveals other instances too, when the trial court wrongly berated counsel in front of the jury. After a number of such incidents, Mr. Williams' counsel, out of the jury's present, moved for the jury judge's recusal and sought a mistrial on the grounds that the judge had shown lack of objectivity, had displayed bias against Mr. Williams and his counsel, and had assisted prosecution in making their case before the jury. Judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before them. In this regard, a trial judge shall avoid all impropriety and appearance of whatever. The Code of Judicial Conduct provides that judges should disqualify themselves in a proceeding in which their impartiality might reasonably be questioned, including but not limited to incidents where the judges has a personal bias or prejudice concerning a party and a party's lawyer. or a party's lawyer. Within the context of this requirement, the word should mean shall. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On the one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, prosecutors must effectively and ethically present the state's case to the jury. At the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed, and that those proceedings are both orderly, ethically, and fair. When these several interests come together in a courtroom during trial, disagreements between the bench and bar are to be expected. The instances discussed above in the Exhibit B joint affidavit, however, represents more than mere frictions between zealous counsels and diligent jurors. The judge's conduct, as discussed above and herein, created the impression that the harbored an inclination to be biased against Mr. Williams and his counsel and partially toward the prosecution. Higher courts need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could be indicated that he has a personal bias or prejudice concerning party or party's lawyer. As explained, the trial judge in this case participated in ex parte communications with the prosecutor in which he insisted the state to influence a witness to testify against Mr. Williams. These actions certainly raise reasonable questions concerning the judge's partiality and bias, because the trial judge's impartiality is a reasonable question. It is an error to deny Mr. Williams' motion for recusal. Our highest court has set for at least 3 circumstances in which recusal of a court is necessary on the ground of mere appearance of bias, even in the absence of evidence of actual bias. Mr. Williams does not waive that actual bias has been objectively shown throughout trial as well as on June 20th. But for simplicity, the appearance of bias is also met. 2 of these circumstances arise in the case. And here's what the number 2 means. The third circumstance in which recusal is required on the ground of mere appearance of bias, absent evidence of actual bias, is when the judge has direct, personal, substantial, precautionary instant in reaching a conclusion against a litigant based upon information and belief. This first mere appearance of bias requires the recusal of a judge when the judge becomes embroiled in a controversy with one of the litigants. Relationships between the judge and the lawyer was such that due process required recusal of the judge, as shown in Exhibit B attached. The court favors the prosecution and is attempting to sabotage the defense. The Georgia courts have followed this demand for recusal when the judge becomes embroiled in controversy. And it gives you the case law. Due process requires that the trial judge cannot be both the prosecutor as well as the judge in our judicial system, and thus must be recused. Where the judge reacted to the supposed continuous conduct in such manner to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted in front of an unbiased, impartial judge. Second, due process requires recusal of the judge, but the judge takes a role in the accusatory process. Our highest court explained that Constitution prohibits a scenario where the judge orders witness to appear before him or her in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the judge presides over the contempt trial. This is because such a judge grand jury arrangement caused the judge to become part of the accusatory process, and thus this judge must be recused from further dealings on the case. Here, Judge Glanville has ordered Mr. Copeland's lawyer and others to appear to give information on the contempt proceeding. Same is against the law. Importantly, a trial judge has the duty to recuse itself from any proceeding in which the judge's impartiality might reasonably be questioned, including instances where the judge has a personal bias or prejudice concerning a party. The phrase impartiality might reasonably be questioned means the existence of an objectively reasonable perception of lack of impartiality by the judge, held by a fair-minded impartial person based upon objective fact or reasonable interference. To warrant recusal, the alleged bias must be of such nature intensity to prevent the complaining party from attaining a trial uninfluenced by the judge's prejudgment. To warrant disqualification of the trial judge, the affidavit in support of the motion seeking same must support the charge of the bent of the mind that may prevent or impede the impartiality of the judge. Mr. Williams meets this mark. Recusal is objectively required when a judge serves both as the accuser and adjudicator. In this case, in the case at bar, the court met ex parte with prosecutors and sworn witness Copeland and never intended to reveal that the ex parte meeting occurred to Mr. Williams and or his counsel or to anyone for that matter. The court has become part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt and failed to reveal any Brady evidence from the meeting, including that the fact that this meeting occurred, that the court and prosecution should not be working together, but they are teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethnical safeguards and protections of due process. The court is biased against the accused and his counsel. No intentionally honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. The court has failed to follow the lawful path. Instead of the court has unlawfully became the prosecutor, judge, grand jury, biased partial potential sentencer, and thus must be removed from this case in toto instanter. On a motion to disqualify recuse, it is the duty of the judge to pass only on the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned, regardless of the judge's personal knowledge of the controversy. The test is whether, assuming the truth of the facts alleged in the tax affidavit, a reasonable person would include bias exists on the part of the judge. So I'm going to go look for something. Okay, this court This court's conduct raises a strong finding that it has become personally embroiled in the case. It is clear, even to the casual observer, that this court's involvement in this controversy requires this court to be disqualified, recused, removed from all further proceedings in the above referenced case. Instanter, I don't know, and another judge who will duly exercise powers of the judicial bench with partiality, clarity, and fairness must be appointed to this case. It is critical to the function of our courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying prosecution that the court will be fair and impartial. The Georgia Code of Judicial Conduct mandates that a judge must disqualify himself in any proceedings in which the judge's impartiality must be reasonably questioned, or which the judge has personal bias or prejudice concerning the party or party's lawyer. The motion to disqualify, recuse Judge Glanville, accompanied by the attached affidavit, mandates that Judge Glanville shall immediately cease to act upon any matters involved in State of Georgia versus Jeffrey Williams. Shall immediately determine the timeliness of this motion and legal sufficiency of the attached affidavit, and assume that any and all facts alleged in the affidavit to be true. Whether recusal will be warranted if it is found that this motion is timely filed, which it is, the affidavit is legal sufficient, which it is, and that recusal will be authorized if some or all the facts set forth in the affidavit are true, which it does. Judge Glanville must cease from any further contact with this case, and another judge shall be assigned to hear this motion to disqualify, recuse Judge Glanville. Judge Glanville cannot in any way oppose this motion. The attached joint affidavit clearly set forth the facts and reasons for the belief that the bias and or prejudice exists in part of Judge Glanville. The allegations in the attached affidavit are not just bare conclusions and opinions, but are facts. Georgia Code of Judicial Conduct mandates that Judge Glanville must disqualify, recuse himself from the case. In the alternative, another judge must be assigned to this case, and then order Judge Glanville recused based upon this conduct as stated herein and in the attached affidavit. The facts cannot be ignored to it. Judge Glanville's impartiality might reasonably be questioned by an objective observer, and thus Judge Glanville must be disqualified, recused from this case. A fair-minded and impartial person would hold a reasonable perception that Judge Glanville lacks impartiality based upon objective facts set forth in this motion and attached affidavit or reasonable references. Reasonable perception of lack of impartiality held by a fair-minded and impartial person is based upon objective facts or reasonable interference. Furthermore, Judge Glanville's potential bias is of such nature and intends to provide Judge Glanville from being uninfluenced by his prejudgment. Judge Glanville conduct gives fair support to charge of bent of mind that may prevent, impede, or partiality of justice if Judge Glanville is not disqualified. Recusal from this case. Further, this indictment must be dismissed or a mistrial granted based upon the court's and prosecution's continued misconduct as shown in Exhibit B attached here on a constitutional required fair trial occurring before a fair tribunal with ethical prosecutors has been violated. This includes, but is not limited to, witness intimidation. Judge Glanville, lawyers for the state, Love and Hilton will be called as witness at a trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Additionally, Mr. Williams demand all ex parte meetings be disclosed instantaneously in order to properly reveal the full extent of all violations of law, ethics. Again, lawyers for the state, Love and Hilton, and Judge Judge Glanville are necessarily witnesses at this hearing and trial to determine the correctness of the motion for mistrial quoted by conduct of these parties. Based upon the above attached affidavit, if Judge Glanville does not immediately recuse us from any of the further dealing in this case, this must be set down before another judge to determine why Judge Glanville Carr continued to serve as judge in this case. Furthermore, a mistrial must be granted based upon this judicial and prosecution violations of law this June 17th of June 2024. So, that's the end of that. But Exhibit A, yeah, this was the paperwork for Brian Steele, but we don't want Exhibit A. We want Exhibit B. Exhibit B is the money. Exhibit B is gonna tell us everything. Hey man, if you come in and out this room, click the like, click the share, click the subscribe, hit the bell, click all. You want to know how your favorite channel got to 1 million views? It got to 1 million views by clicking like, share, subscribe, and hitting the bell. Why? It doesn't hurt you. It only helps the channel grow. And when the channel grow, I can get better and I can do better shows and I can do better podcasts. But let's get back to reading the paperwork. I think I'm going to put the coffee away. I need the tea with the fruit in it. And the little straw that's too little. All right. So, now this is the paperwork that's going to give us all the information. This is the paperwork that's going to tell us what happened in this secret meeting. And this paperwork also tells us that Mrs. Bumpkiss, or whatever her name is, she was the mole. She came in for one day to represent Mr. Copeland, aka Little Woody, who was the informant. She came in to represent him, and she did good, because on her first day of representing the informant, she told Brian Steele, Young Thugs and the attorney, that, hey man, they having secret meetings, they doing stuff behind y'all back, and this is it. This is why Judge Glanville, he didn't want to let her go off the case, because he knew that she was the mole. He knew it. But, like I said, man, if you coming in here, click that like, click that share. Y'all YouTubers love looking at information for free and don't show y'all love. But let's read this. We only got 6 pages. And you know I'm going to come right back with another lie, because I got another story about Ray J being there the night Whitney was died and he possibly sold her bad drugs. That will be my next video. So, let's see what was happening in this secret meeting. So, joint affidavit of Brian Steele and Keith Adams. These are 2 lawyers filing a motion. And we are over the age of 18 and suffer no legal disability. We make this joint affidavit based upon our personal knowledge. We are counsel for Jeffrey Williams in above style case. On Monday, June 10th, 2024, and thereafter, affidavits learned the following events in fact occurred outside Mr. Williams' presence and outside of affidavits' presence and in Star Chamber-like environment. On Monday, June 10th, 2024, undersigned affidavits, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized, and applicants requested the actual recording of anything discussed at this improper in-chambers meeting and said date. This court has instructed Mr. Williams and below applicants from having an exact image of what was said. This obstruction alone shows that this court is biased, and as there is absolutely no privilege in communication in the court chamber, as the court argued on June 10th, 2024, and there is certainly no attorney-client privilege under any stretch of the imagination, as the court asserted. This obstruction conducted by the court shows bias in that this court is, interestingly entwined in the facts of this case and has prevented Mr. Williams from due process, fair trial, and effective assistance of counsel. Right to know every material and critical happenings in this case. Further, this court, by its words used on record when speaking in open court with applicants, as well as the court silence, as well as lawyers' love statements in open court, clearly demonstrate the facts below are true and accurate. The court also silenced witnesses by improperly issuing a show cause order for contempt, and thus making all witness in fear of going to jail if the truth is told about the improper violations of Mr. Williams' constitutional right to be presented at every critical stage of his trial. Fair trial. Critical stage of his trial. Fair trial. Fair tribunal. Effective assistance of counsel, due process under the law, the right to make a record on the case. The court is biased and must be recused. Further, the cross-examination of Mr. Copeland will include facts that occurred at this Star Chamber meeting, which puts the credibility of Lawyer Love, Lawyer Hilton, this case and issue in this court should never be the person who is in charge of the jury when the court's conduct is being questioned based upon the courts and lawyers for the state of Georgia's action. Mr. Williams has been put into a trick box by the misconduct of Lawyer Love, Lawyer Hilton, and this court. This court must be recused. A mistrial declared, barred by double jeopardy based upon prosecutorial misconduct and judicial misconduct. So what they action here is to not only kick the judge off, they want a mistrial. Excuse me, I'm 420, really. Sometimes we gag a little bit. I'm sorry about that. But if you in here, please click the like, share, subscribe, hit the bell, click all. It's not gonna kill you. It's free. It's not gonna hurt. It's only gonna help a small channel grow. But so what's going on? They asking for mistrial and bar from double jeopardy, so they want mistrial and they can't refile these charges. So they asking for a lot, but rightfully so, because this judge violated the law. Mr. Kenneth Copeland, a witness who had been called by the state and sworn on Friday, June 7th, 2024, who invoked his Fifth Amendment and was held in civil contempt by this court, was brought to the Fountain County Courthouse on Monday morning, June 20, 2024, unbeknownst to applicants. Mr. Williams or anyone else on the defense side of this case. This court met in its chambers with Mr. Copeland, his counsel, Lawyer Love, and or Lawyer Hilton, and at times court reporter Weaver, as well as sheriff deputies and other persons. Deputies may have been instructed to turn off their body cams. There was and is nothing privileged under law about this improper ex parte meeting. This court and the others met with Mr. Copeland for a lengthy period of time. The total ex parte meeting lasted for more than 1 hour, approximately 2 hours, with the above named people at the meeting at all or various times. Mr. Copeland continued to make known his assertion that he would not testify, even in the face of being held in contempt in order to testify under his immunity. So, Lil Woody, even after being locked up for the whole weekend, was still telling them people like, yo, I'm not gonna tell, I'm not gonna testify. And the judge, which is illegal, told that man, I lock you up. And Woody was ready to stand 10 toes down and say, well, lock me up. I'll do the 2 years. But then they told Woody, well, nah, it's going to be longer than 2 years because we got 12 more people after this to bring the trial. So you going to stay locked up through that. So now in little Woody mind, he like, damn, I was ready to hold it down for 2. But for another 4 or 5, nah, I can't do it. So they forced him to testify, which a judge can't do that. You know what I'm saying? A judge can't force you to testify. So, let's get back to court, and the others met with Mr. Copeland for a long period of time, 2 hours. Mr. Copeland continued to make known his assertion that he would not testify, even in the face of being held in contempt in order to testify under his immunity. This court and lawyer for the Fulton County District Attorney's Office, Love and or Hilton, ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies. Alternatively, he persisted in refusing to testify. He would be held in custody until not only Mr. Williams' current trial resolved, but until all 26 indicted person cases are resolved, which is no longer this court was a participant and was present during this admonitions, threats to Mr. Copeland. This is witness intimidation, coercion, and the court has become a member of the prosecution team and assisting the prosecution to induce a material witness to testify. The court, lawyers Hilton and Love are now all witnesses in this case and will be called by Mr. Williams and or possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all relevant material persons that have information to share with the jury regarding the conduct, words, and action of this ex parte communication. So what you got to understand is what they're saying is, Judge, you a witness. D.A. Love, you a witness. D.A. Hilton, you are now a witness in this case. You three possibly can't go on because you can't be a witness. You can't be the judge and the prosecution. You can't be all those things. So, in all reality, you're going to have to throw this case out. You're going to have to throw this case out, or you're going to have to get a whole new prosecution team and a new judge because y'all are now witnesses because y'all had these secret meetings. And so now the case is really messed up. But let me continue reading. Remember, please click the like, share, subscribe. It ain't gonna hurt you. It's only gonna help the channel grow, and I can give you better videos. As you can see, I can get paperwork. This was filed today. This paperwork is only hours old. Every channel ain't got it. This court provide Mr. Copeland with a written copy of the statute on crimes of perjury as well as false swearings. This is no subtle gesture and one that helped the prosecution team to attain their mission for Mr. Copeland to change his mind and testify. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel, sheriff deputies, the court reporter and others that Jonathan Mellick, counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland and was not representing the interests of Mr. Copeland. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitted Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland, adds to the coercion and witness interrogation. The ex parte discussion violated Mr. Williams' constitutional rights pursuant to article, section, paragraph of the Georgia Constitution to be present at every material stage of this trial. The court and Lawyer Love and or Hilton speaking with Mr. Copeland, a sworn witness, about his testimony and whether he would change his mind and testify is clearly a critical stage of these proceedings. As asserted in the motion to recuse, this court filed at 10:40 p.m. on June 14, 2020, Attorney Bumpus, by her counsel, verified the below facts. These facts are adopted into the Athens affidavit as below. These facts are asserted of Attorney Bumpus as statements of her lawyers. So, if you don't know, Attorney Bumpus only came there for one day to fill in for Limpkin or whatever the hell his name was. He was Mr. Copeland's original attorney, but he claimed he had some tickets that he couldn't refund, so he sent her in. And remember, she's just a black, beautiful attorney, Attorney Bumpkins. She does, I think, accident cases. She makes a lot of money. She gets paid, and she just came in to fill in. So when she came in, she got called into the secret meeting. And she like, yo, they having secret meetings. They trying to lock Young Thug up. She probably was a fan. You never know. But she told, which is her job. The law says if you see any improper things as an officer of the court, you have to report that shit. So she did right by going to Young Thug's attorneys. And this is her statement. And remember, Judge Glanville didn't want to let her go because he didn't want to let her go because he knew she was the mole. He knew because she was the only one who probably wasn't in on other secret meetings, and they had other secret meetings and they didn't tell. So he knew. But let's get back to the paperwork. These facts are assertions of Attorney Bumpkins as statements of her lawyers. As follows: on Monday, June 10, 2024, at approximately 8:30 a.m., Mr. Copeland and his lawyer, Attorney Kayla Bumpus, were escorted to the court chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. Those present for the substantive position of this ex parte meeting were Judge Glanville, Mr. Copeland, Attorney Bumpus, lawyers Love and Hilton, members of the court security staff, and deputies. 2 investigators from the Fulton County District Attorney's Office and the court reporter. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Mr. Copeland announced that he planned to again invoke his Fifth Amendment privileges on the stand. A conversation. Where we at on this? Hold on. Let me plug my laptop up. I'm sorry. Let me plug it up. It'll take 1 minute. See, that only took 1 minute. That's it. That's all it took. Let me make sure I'm juiced up, because sometimes my shit play with me. There we go. So, as inserted in her motion, let me see, where was I? Damn. Okay, so we gonna go back to Mr. Copeland, Attorney Bumplin's lawyers, love and help with members of the court security staff, and 2 investigators from the Fulton County District Attorney's Office, and the court reporter in chambers. This court asked Mr. Copeland whether he was prepared to testify. Mr. Copeland announced that he planned to again invoke his Fifth Amendment privileges on the stand. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity, how Mr. Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Mr. Copeland learned he could be held indefinitely by the court, he refused to testify, not just 2 years as he initially believed. Mr. Copeland decided that he would testify. Mr. Copeland added that his testimony would be a lie. The meeting ended and all parties went to the courtroom. So, what's going on is that this man told the court, yo, I'm not testifying. I'm a plead the Fifth in the secret meeting that none of the the defense team was there. He told them, yo, I'm gonna lie. Or first he told him he gonna plead the Fifth, and they told him, oh, you can't plead the Fifth, and they showed him how much time he can get, and they did all type of shady shit, which ain't right. But that's what they did, and the man changed his mind. Now, he was ready to do 2 years. He thought he would only do 2 years if he pleaded the Fifth. But they told him, like, yo, it's 26 people. You're going to be locked up to all 26 of those people, either plead guilty or go to trial. That could be like 4 or 5 years, because this trial is not scheduled to end till 2025, 2027. So he like, man, I'm not going to do all that time. But anyways, let's continue to read. We almost done. Hang in there. 4 more pages. Hit his brother with a like, a share, subscribe. The court never assured that this Brady evidence would be revealed to Mr. Williams or his counsel. And Brady's evidence includes the fact that this meeting occurred. Instead, this court takes a position that no information about this meeting should have been revealed to Mr. Williams, his counsel, or anyone outside the Star Chamber, where same occurred. This shows that the court has become a member of the prosecution team in an effort to thwart Mr. Williams' constitutional right to a fair trial and a fair tribunal in due process, and right to be presented for equal critical stage of its proceedings, right to call witnesses, right to present a defense, right to cross-examine witnesses on critical topics, including the facts of this case were discussed with the court during the intimidation of the witness. This court must be recused. The court and the prosecution have violated Mr. Williams' right, and the indictment must be dismissed after a mistrial is declared, as the court and the state has gored Mr. Williams into moving for his mistrial recusal of the court on Monday afternoon, June 10, 2024, at approximately 1 p.m. Once affidavits made the above known in open court, the court refused to release the transcripts of the improper ex parte occurrence held. Mr. Williams' lawyer, in contempt of court, ordered Mr. Williams to serve maximum period of time in custody for contempt, all in an attempt to intimidate Mr. Williams and his counsel from understanding and learning about the court's and the prosecution's wrongdoing. The court has become a material witness because the undersigned counsel has a right for the jury to understand that this court met with Mr. Copeland and the prosecutors, and in order to convince Mr. Copeland to testify against against Mr. Williams. Could you imagine that, right? That when the defense gets up, technically they have the right to call the judge and say, hey, you had a secret meeting. What was going on in that secret meeting? What was y'all doing in that secret meeting? Could you imagine that? That's crazy. The court has become a material witness because undersigned counsel has a right for a jury to understand that the court met with Mr. Copeland and the prosecutors in order to convince Mr. Copeland to testify against Mr. Williams. This improper ex parte meeting on June 10th, 2024 was a sworn witness concerning the witness' willingness or non-willingness to testify in this court, giving the witness a copy of the law of perjury and false statements and discussing facts of this case is unforgivable. This is not an ex parte meeting that the court has had with affidavits ever, or the very few occasions that the affidavits have had in ex parte hearing with this court. Affidavits announced in open court that it needed to speak with the court ex parte. There was no objection by the prosecution, and same occurred. Never was a witness involved in these rare ex parte meetings. Affidavits demand to question this court and the above lawyers for district attorney's offices as to how many ex parte hearings they have had. The substance of these meetings, who was present, substance of those meetings, who was presented, and the like. Even if just one ex parte meeting occurred, as did on June 10, 2020, this mandates that the court has forfeited its role as an impartial judge and has become a member of the prosecution team. The court must recuse itself. The court on at least one occasion have been fed improper ex parte information and facts of this case in a witness statement about his recusal to testify. The court met with a witness and spoke with the witness about the witness willingness or non-willingness to testify along with prosecution, and then held undersigned counsel in contempt when undersigned counsel simply wanted to know why he was not notified of this ex parte judicial and ethical prohibiting meeting. This court has now placed a lawyer for Mr. Copeland and other unknown persons in a position that they need to come before the court on a date certain to give testimony as to who gave information to affidavits concerning this improper June 10, 24 Star Chamber meeting with Mr. Copeland. The prosecutors in the court. The court has become the executive branch conducting an investigation as a grand jury / prosecutor. This court has lost all impartiality, and Mr. Williams cannot receive a fair trial with his court being present over the proceedings. This court has falsely and wrongly accused affidavits specifically Brian Steele of being unprofessional and unprepared in front of the jury. Neither claim was close to the truth or was accurate. The prosecution sat silent as affidavit was wrongly and falsely accused of improper conduct. This court has violated every neutrality and partiality that it was sworn to undertake. Relevant law quoted in the attached motion and adopted and applied upon hearing. Even knowing that the court has falsely accused Brian Steele of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. This clearly shows that this court is biased and impartial against Mr. Williams and or his counsel and in favor of the state, as no fair judge would not correct such a serious mistreatment made in front of the jury. The bias of the court is objectively proven. When Mr. Copeland took the witness stand on Friday, June 7th, he refused to testify and was taken into custody by this court. The court knew, as did the prosecution, that Mr. Copeland would refuse to testify in front of the jury, but the court did not reveal that fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Mr. Copeland's refusal to testify in front of the jury prejudiced Mr. Williams a great deal, and the jury should not have heard Mr. Copeland exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit the media from filming Mr. Copeland when the court ordered him to be arrested. The direction occurred before Mr. Copeland even took the witness stand on Friday, June 7, 2024. The court has harmed Mr. Williams by hiding this information from Mr. Williams. Having ex parte communications with the deputy and media and permitting Mr. Copeland to assert his Fifth Amendment right in front of the jury when the Honorable David Box Esquire brought to the court's attention that he had evidence that the prosecution knew that Mr. Copeland was going to invoke his Fifth Amendment right in front of the jury. This court refused to have a hearing to determine whether the prosecution knew that this witness would invoke his right to remain silent and refused to testify. Instead, the court had a problem with attorney Botts. This is backwards. The court has shown bias against Mr. Williams, his lawyer, and in favor of the prosecution. This court must be removed from further dealings on this case. This trial must be mistried based upon Gordon and improper conduct by the court. And the prosecution in another trial is prohibited and barred by double jeopardy. So what they trying to do is trying to get this thrown out with no double jeopardy, which would mean that these boys can't be tried again. I mean, with all the stuff I done read in this, and I'm not a lawyer by far any means. I've been a criminal that hired lawyers, but they can't lose. This judge has to take himself off the case. Now, I don't know about throwing the case out. That's something different, but they have to throw it out. But anyway, so let me finish. We only got 2 pages. I mean, you know, people been in and out. I wish people would click the like, share, subscribe, and hit the bell. Show a small channel some love. Help me get to 1 million subscribers. Help me get 1 million views. Why not? It ain't gonna hurt you. I'm just an OG from the hood trying to be on YouTube. I'm actually trying to save my hood. In my city, they're going crazy and they killing each other, and all my videos are about to be based on trying to get these kids in my city to stop killing themselves so they don't be dead or part of some Rico. So hit that like, hit that share, hit that subscribe. Let me get my platform up there so I can help my city. But anyways, in the sum, the court must be recused and or the trial be declared mistried based upon improper judicial and prosecutorial conduct that includes but not limited to the court lawyers Love and or Hilton are non-witnesses because they helped Mr. Copeland change his mind and testify by coercion. Or, you know the word. The court ex parte assisted the prosecution by convincing Mr. Copeland to change his mind and testify against Mr. Williams. The court has instructed justice by ordering any transcript of the June 10th, 2024 ex parte meeting not to be produced to the evidence to use to particularize this affidavit as well as to cross-examine Mr. Copeland, the court, the lawyers for the state, and or others before the jury. Facts of this case were discussed with the court after this impermissible ex parte meeting, and Brady evidence was not revealed to the evidence by court and or the lawyers for the state. And Mr. Williams has questions for Mr. Copeland, this court, lawyers for the state, and others about this improper ex parte meeting, how same occurred, who discussed the fact that this is a secret meeting which occurred, and the substance of this meeting, so the jury can decide whether the court and the state have colluded against Mr. Williams. I swear that the above is true and accurate. So there you have it. This is the certified. I have this day served a copy of the within and foregoing motion to disqualify, recuse Judge Granville from all further dealings. So this was Brian Steele, but as we read, Attorney Bumpkiss, she even filed a motion for this judge to be removed. So everybody is trying to remove this judge. And if you have any type of brains whatsoever, he has to be removed. You know, he just did all type of crazy things. He's broken the law. He's went above and beyond to help the prosecution. And if, you know, you got any bit of sense, you know, Stevie Wonder and Ray Charles sitting there like, yo, you see this shit? You see what they doing to Young Thug? But like I always say, man, you know, this is official paperwork, man. Not too many channels is giving you the official paperwork. Hit that like, hit that share, hit that subscribe, hit that bell, click all so you can get notifications every time I got this official paperwork or every time I do a review. Why not? It doesn't hurt you. It only helps the channel grow. Then I can become a channel with 1 million subs and millions of views, and I can build a bigger and better platform, start bringing you some interviews, because that's the plan. Like I always say, if you're a supporter of the channel, much love and respect. And if you're one of them haters, cut the shit.